After my husband died, his mother stood in my kitchen and said, "I'm taking the house, the law firm, all of it. Everything except the daughter." My attorney begged me to fight her. My mother begged me to fight her. My best friend called me every night and told me not to let that woman steal what Joel had built. But I said, let her have it. Everyone thought grief had broken something inside me. They thought I was too tired, too shocked, too weak to understand what I was signing away. Then came the final hearing. I signed the papers while Carla sat across the table, smiling like she had just won the lottery. She kept smiling until her lawyer went pale, because that was the moment she finally realized exactly what she had accepted. My name is Miriam Frettel. I was 31 years old, and until recently I lived in Covington, Kentucky, a small city sitting right across the Ohio River from Cincinnati. The kind of place where people wave from their driveways and somehow know what you paid for your house before you have finished unpacking. I married Joel Frettel when I was 24. He was a personal injury attorney who had built his own firm from absolutely nothing, or from what his mother always called nothing, which meant her $185,000 loan and about 6,000 hours of Joel's sweat. He began in a tiny rented office above a flooring store on Madison Avenue, the kind of office where you could hear customers choosing laminate samples through the floorboards while clients sat across from him describing the worst days of their lives. Within 5 years, he had moved into a real office suite, hired a small staff, and was billing more than $600,000 a year. Frettel and Associates. His name was on the door, and his mother never let anyone forget who had paid for that door. Joel died on a Thursday evening, March 6th, from cardiac arrest. They found him at his desk at the office, his hands still around his coffee mug. He was 36 years old. I got the call while I was giving our daughter Tessa a bath. I drove to the office with wet sleeves rolled to my elbows and soap still under my fingernails, and by the time I arrived, the paramedics had already stopped trying. The funeral was the following Wednesday. Carla, Joel's mother, wore black Chanel sunglasses indoors, the kind that cover half your face so nobody can tell if you are crying or just performing grief for an audience. Joel's younger brother Spencer stood beside her, looking like a boy waiting outside the principal's office. He was 29, had never kept a job longer than 5 months, and lived in Carla's guest house in Burlington, where his main responsibilities seemed to be sleeping until noon and ordering things online with her credit card. You need to understand something about Carla. She was not a helpless old widow with no idea how the world worked. She had owned 4 dry cleaning stores across northern Kentucky and built them herself after divorcing Joel's father. She understood business. She understood numbers, or at least she believed she did. Dry cleaning is simple math. Clothes come in dirty, clothes go out clean, cash goes into the register. She applied that same logic to everything, including a law firm she had never professionally set foot inside. To Carla, Joel's practice was just another store, only instead of pressing shirts, you pressed lawsuits, and instead of coins in a machine, $600,000 a year rolled through the books. From the first Thanksgiving after Joel brought me home, Carla treated me like a temporary inconvenience he would eventually outgrow. I had been a legal secretary when we met, not glamorous, not rich, not from the right family. Once, while Joel and I were standing right there and very much married, Carla introduced me to her friends as Joel's first wife. So when she appeared in my kitchen 11 days after the funeral, I should not have been surprised. But grief does something to your reflexes. It makes you slow. You stand there absorbing blows you would normally see coming from across the room. Carla walked in wearing a gray blazer, dressed for the occasion as if reclaiming my life was a business meeting. Spencer followed behind her with an actual tape measure. While Carla stood at my kitchen island explaining that she was reclaiming what her investment had built, Spencer wandered into the guest bedroom and started measuring the closet. I could hear the tape clicking and snapping from the kitchen. I remember staring at my cold coffee and thinking, what does he even own that could fill a closet? The man's most valuable possession was probably a gaming chair. Carla laid out her case like she was presenting to a board. The firm had been built with her money. The house down payment, $30,000 she had given us 7 years earlier and had mentioned at every holiday since, had come from her. In her mind, she was co-owner of everything Joel had ever touched. And now that he was gone, she wanted her investment back with interest. The only thing she did not want was Tessa. She said it so matter-of-factly, like she was refusing a side dish at a restaurant. No thank you, not the child, just the assets. I stood there holding coffee that had gone cold 20 minutes earlier and said nothing. Not because I agreed, but because my brain could not process losing my husband and being robbed in the same month. 2 days later, a certified letter arrived from Axel Mendler, attorney at law. Carla had filed a formal contest of Joel's will and a creditor's claim against his estate for the $185,000 loan. This was no longer a cruel kitchen table ambush. This was a legal attack, launched before the flowers on Joel's grave had even wilted. And while I was still sleeping in a bed that smelled like my husband's cologne, trying to explain to a 4-year-old why Daddy was never coming home, Carla had gone from threats to court filings in 48 hours. Axel was no amateur. He filed the will contest on grounds that sounded solid enough if you did not look closely, arguing that Carla's loan had really been an investment in the firm and gave her a claim to its value. He also filed a separate creditor's claim for the loan itself. Two legal fronts at once. Carla was spending $350 an hour and wanted results fast. But Carla was not content to wait for the legal system. She decided to start managing her new empire immediately. The week after the filing, she drove to Joel's office, Fredel and Associates, a second-floor suite on Scott Boulevard, and walked in like she already owned the place. She introduced herself to the staff and announced that she would be assuming oversight of operations and that changes were coming. There were only 4 employees, 2 paralegals, 1 receptionist, and Gail Horvath, the bookkeeper who had been with Joel for 6 years. Carla told Gail to print the firm's revenue reports for the last 3 years. Gail printed them. Carla looked at the top line. $620,000 in annual billings, nodded like she had just confirmed what she already knew, and left. She never asked for the expense reports. She never asked about debts. She never opened a single folder that was not labeled income. It was like checking a bank balance by looking only at deposits and deciding you were rich. Then she started calling Joel's clients one by one, tracking down their numbers and introducing herself as the person who would be overseeing the transition. She had no legal authority to do this. She did not have a law license. She did not even know what half of Joel's cases were about. But Carla believed confidence and competence were the same thing, and she had more confidence than anyone I had ever met. Most of Joel's clients, understandably alarmed by a phone call from their dead lawyer's mother, transferred to other firms within days. Carla was systematically destroying the revenue stream of the very business she was fighting to own. It was like watching someone set fire to a house while arguing with the insurance company over how much the house was worth. Then Spencer happened. A week after Carla's office visit, he pulled up at my house in Carla's Buick Enclave with 2 duffel bags, a PlayStation, and a large bag of barbecue chips. He came to the front door and announced that he was moving into the guest room because, in his exact words, Mom said it's basically ours now. He had not brought sheets, a pillow, or a single piece of professional clothing. He brought a game console and snacks. I told him to leave. He refused, so I called the Covington police. 2 officers arrived, confirmed that the house was in Joel's name and that I was the surviving spouse, and escorted Spencer back to the Buick. He left the chips on my porch. I threw them away. That night, Carla called me. Her voice reached a pitch I did not know human vocal cords could make, somewhere between a smoke alarm and an opera singer rehearsing a death scene. She told me I was heartless and cruel, and that Joel would be disgusted with me for throwing his brother onto the street. I reminded her that Spencer lived in her guest house and had his own bedroom there. She hung up on me. Meanwhile, my own people were losing faith in me for different reasons. My mother drove up from Lexington that weekend, sat at the same kitchen table where Carla had announced her hostile takeover, and said, "Honey, you have got to fight this." My best friend Shannon called every night and said the same thing. Get a lawyer. Get a shark. Do not let this woman steamroll you. So I hired Lyra Schmidt, who came recommended by one of Joel's colleagues. Lyra was a German-American woman in her mid-50s with silver-streaked hair and the kind of calm, precise energy that made you believe things might actually become manageable again. She had handled estate disputes for 20 years. She reviewed Carla's filings in about 40 minutes and told me they were beatable. The loan had no partnership agreement, no formal terms, and nothing in writing giving Carla equity in the firm. Joel's will was clean and properly executed. Lyra said, "We fight, we win, and Carla goes home with nothing but a lesson in contract law." I told her I needed a few days to think. That night, after Tessa was asleep, I drove to Joel's office. It was almost 9. The building was dark except for the green glow of the exit signs in the stairwell. I unlocked Joel's private office with the spare key. I still kept on my keychain and sat at his desk. It smelled like him, like coffee and the sandalwood aftershave he had worn since college. I opened the deep bottom drawer, the one where he kept files he did not want anyone else touching. Behind a stack of old case folders, I found a sealed manila envelope. My name was written on the front in Joel's handwriting. Not Miriam Fredel, just Miriam, with a small heart beside it, like we were still passing notes in high school. I opened it. I read what was inside, then sat in that dark office for almost an hour, without moving, without breathing hard, and without crying. For the first time since March 6th, my mind was completely clear. The next morning, I called Lyra. My voice sounded different even to me, steady and calm, like something had clicked into place behind my eyes. I said, "Lyra, I've changed my mind. I don't want to fight. I want to give Carla everything she's asking for. Everything." Lyra did not speak for about 10 seconds. And for a woman who bills by the hour, 10 seconds of silence is practically a medical event. I need to explain what was in that envelope, because this is where the story changes direction. If you do not understand what Joel did in the last months of his life, nothing that happened next will make sense. 8 months before he died, Joel had been diagnosed with a serious heart condition. He had been having episodes, shortness of breath from simple things like climbing stairs, tightness in his chest that came and went, and a strange exhaustion sleep never fixed. He finally saw a cardiologist in Cincinnati, a specialist at one of the big hospital systems across the river, and the diagnosis was bad. Not immediately fatal, but the kind of bad where doctors use words like progressive and long-term management while looking at you as if they are sorry they ever went to medical school. Joel told me in the envelope that he had not told his mother, his brother, or anyone else. You need to understand something about my husband. He was a personal injury lawyer. He had built a career around watching lives fall apart because someone did not plan, because someone cut corners, because someone assumed everything would be fine. He was not going to let that happen to his family. So during those 8 months, while he still went to the office every day, still wore his good suits, still smiled through Sunday dinners while Carla bragged about his big cases, he was quietly and methodically arranging the pieces. The envelope contained 3 things. The first was a handwritten letter dated 5 weeks before he died. It was not a financial document. It was a letter from my husband to me. He wrote about Tessa, about how she had started calling butterflies flutterbees, and how he never wanted to correct her. He wrote about our kitchen, about the way the morning light came through the window over the sink and hit the counter at exactly the angle that made everything look golden. He wrote about the day we met, when I was 22 and working at the front desk at Bernstein and Kellogg, the law firm where he was a junior associate. He asked me to lunch 4 times before I said yes, because I had a strict policy about not dating lawyers, a policy that clearly did not hold up very well. The last line of the letter was the line I would read over and over again. Don't let her take what matters. She can have the rest. It was not a set of instructions. It was not a scheme. It was trust. Joel knew I was smart enough to understand what he meant once I saw the second and third things in the envelope. The second thing was a set of beneficiary confirmations. Joel had a life insurance policy worth $875,000. He had taken it out years earlier, when he was 30 and just starting the firm, because the bank had required it as collateral for his startup business loan. Back then, he had been young and healthy and had passed the medical underwriting with no problem. The policy had been active for 6 years. In his final months, all Joel had done was update the beneficiary. 1 form, 1 signature, done. He made me, Miriam Fredel, the sole beneficiary. And that mattered because that money would pay directly to me when he died. It would never enter the estate. It would never go through probate. Carla could not touch it. Even if she knew it existed, which she did not, she would have no legal claim to it. He had done the same thing with his retirement accounts, a 401k with about $152,000 and a Roth IRA with about $58,000. He updated both beneficiary designations to me. Same principle. Named beneficiaries receive those funds directly, outside probate and outside the estate. That was another $210,000 Carla could not reach. I want to be clear about this. It was not some secret loophole. It was not trickery. This is how life insurance and retirement accounts work in every state in America. Millions of families rely on beneficiary designations exactly this way. Financial advisors tell people to check those forms every year. It is not a magic escape hatch. It is Tuesday afternoon paperwork that most people put off until it is too late. Joel did not put it off. The third thing in the envelope was the real financial picture of Fredel and Associates. Joel had prepared a detailed summary in that precise lawyer handwriting of his, laying out every debt, every liability, and every ticking bomb hidden inside the beautiful-looking firm his mother was so desperate to own. That was the moment I stopped feeling only like a grieving widow and became something else entirely. The firm billed $620,000 a year. That part was true. That was the number Joel mentioned at family dinners. The number Carla memorized like scripture. The number she saw on Gail's revenue reports. But $620,000 in revenue looked very different when you peeled back the curtain. There were $115,000 in accumulated vendor and overhead debts. There was a pending malpractice settlement for $180,000, already agreed to by Joel before his death and just waiting for payment. There were $47,000 in unpaid payroll taxes, and the IRS does not forget about payroll taxes. They treat them as trust fund taxes, which means the responsible party can become personally liable. Then there was the office lease, with 34 months remaining at $4,200 a month. That was $142,800 in rent for a space you could not simply walk away from. The house looked valuable at first glance, worth about $385,000, but Joel had taken out a $220,000 home equity line of credit 18 months earlier to keep the firm afloat. Add that to the original mortgage balance of $160,000, and the total debt on the house was $380,000. After closing costs, realtor fees, and transfer taxes, selling the house would net exactly nothing, maybe less than nothing. And Carla's precious $185,000 loan, she was an unsecured creditor. That meant she would be last in line behind the IRS, behind the malpractice plaintiff, behind every vendor, every landlord, and every creditor with a signed contract. By the time all those people were paid, if they were paid at all, there would be nothing left. Carla's loan had died the day Joel did. She just did not know it yet. I sat in that office doing the math on the back of a grocery receipt. My side came to about $1,085,000 in clean, non-probate assets, tax-advantaged, protected, already mine. Carla's side came to approximately negative $520,000 once every real liability was counted and every real asset was stripped of its fantasy value. The next day, Gail Horvath called me. She was Joel's bookkeeper, the woman who had managed his books for 6 years, and Carla had fired her the previous week with no severance and no notice. After 6 years of keeping that firm organized down to the penny, Gail was hurt and furious. She confirmed every number in Joel's summary. She also told me the detail that made me close my eyes and breathe. When Carla came into the office, she had asked only for revenue reports. Gail printed them. Carla studied them carefully, nodded, and left. She never asked about expenses. She never opened the liabilities folder. She looked at one column on one spreadsheet and decided she was inheriting a gold mine. I called Lyra again the next morning and said, "Do not fight. Offer Carla everything. The house, the firm, every account in the estate. All I want is full, sole custody of Tessa. No visitation for Carla." Lyra told me to come to her office. I brought Joel's envelope. I laid everything on her desk, the beneficiary confirmations, the financial summary, and the math. Lyra read through it all. She checked the numbers twice. She looked at the insurance confirmation, the retirement account designations, and the firm's debt breakdown. Then Lyra Schmidt, a woman who had spent 20 years in estate law without flinching, leaned back in her chair and started laughing. Not a polite little laugh, but a real one, the kind where your eyes water and you have to take off your glasses to wipe them. She looked at me and said 2 words. Joel was brilliant. Then she picked up her pen and began drafting the settlement offer. Lyra contacted Axel Mendler the following week with an offer that, on paper, looked like total surrender. Miriam Fradel would relinquish all claims to the estate assets, the firm, the house, and every bank account connected to Joel's name. In exchange, Miriam wanted only 2 things: full sole custody of Tessa, with no visitation rights for Carla, and Carla would permanently drop the will contest. That was it. Take the empire. Leave the child. Axel, to his credit, was suspicious. When someone hands you everything you asked for without a fight, any decent attorney starts looking for the trap. He called Lyra back and said he needed more time. Specifically, he wanted a full forensic audit of the firm's finances. He asked Carla for 2 weeks to go through the books properly. 2 weeks. That was all he asked for. Carla said no. And here is the thing. From her perspective, her reasoning was not stupid. She had watched me for 7 years. She had seen a quiet, polite woman who did not argue, did not push back, and did not raise her voice through a single holiday dinner, no matter how many times Carla called me Joel's first wife or asked when I planned to do something meaningful with my life. In Carla's mind, I was finally doing what Miriam always did, folding. And if you think you are holding the winning hand and your opponent tries to leave the table, you do not say, "Wait, let me double-check my cards." You take the pot. Carla told Axel, "I've seen the revenue, $620,000 a year. My son built that with my money. Get me those papers before she changes her mind." Axel pushed back hard. He drafted a formal advisory letter, 2 pages, single-spaced, stating that due diligence on the firm's financial position was incomplete and recommending that Carla wait for a full audit before accepting any transfer of assets and liabilities. Attorneys do that to protect their clients, and Axel was also protecting himself beautifully. Carla read the letter, signed the waiver at the bottom, acknowledging that she was proceeding against counsel's recommendation, and told him to schedule the signing. There was one more thing, Axel asked Lyra directly. He wanted to know whether there were any non-estate assets they should be aware of, such as life insurance policies or retirement accounts with named beneficiaries. Lyra responded exactly as she should have. Non-estate assets were outside the scope of the estate settlement, and her client was under no legal obligation to disclose them. Carla heard this through Axel and dismissed it immediately. Joel had never mentioned life insurance to her. She assumed he did not have any. Why would he? He was 36. He was healthy as far as she knew. Young men do not think about life insurance. Except Joel did, because a bank had required it 6 years earlier, and Joel was the kind of man who kept paying premiums on time even while everything else was falling apart. While Carla was busy signing waivers and ignoring her own attorney's advice, I was quietly building my new life. The insurance company processed my claim in just under 3 weeks. $875,000 landed directly in my personal checking account at a credit union in Florence, Kentucky. I had opened that account specifically for this purpose, with no connection to Joel's accounts and no connection to the estate. I also initiated the rollover of Joel's retirement accounts. $152,000 from his 401k and $58,000 from his Roth IRA into accounts in my name only. I started moving things out of the house, nothing dramatic, just a few boxes at a time. Tessa's clothes and toys first, then my books, my documents, and the photo albums. I found a 2-bedroom apartment in Florence about 20 minutes south of Covington. It was clean, safe, and in a good school district. First and last month's rent came to $1,800. I paid it from my checking account and did not blink. Meanwhile, Spencer was living his best life. Carla had sent him to the firm to manage operations while the legal process played out, which mostly meant he sat in Joel's chair, spun around a few times, and tried to understand the phone system. He called a process server a delivery guy. He asked one of the paralegals what a retainer agreement was. On his third day, Carla had him go to the bank and sign onto the firm's operating account as a co-signer so he could handle day-to-day expenses. Spencer signed every document the bank put in front of him without reading a word. He did not realize he was making himself jointly liable for obligations tied to that account. Spencer never read anything that did not have a screen and a controller attached to it. Around that time, my mother came up from Lexington again. She sat across from me at my new kitchen table, a small IKEA table I had assembled myself, which honestly felt like a bigger accomplishment than my entire marriage at that point, and said, "Miriam, you're giving up Joel's house. You're giving up his life's work. Are you having some kind of breakdown?" I wanted to tell her everything. I wanted to open my laptop and show her the bank balance and watch her eyes go wide. But I could not. Not yet. Not until the papers were signed, and there was no chance of any whisper leaking back to Carla through the small-town telephone chain that somehow connects every mother in Kentucky to every other mother within a 45-minute radius. So I only said, "Mom, trust me, it's going to be okay." She did not believe me. I could see it on her face, but she hugged me anyway, and that was enough. The signing was scheduled for a Tuesday in late June. The night before, I laid out Tessa's outfit for daycare, packed my bag with a signed apartment lease, and a folder of bank statements showing $1,085,000 in clean assets, and set my alarm for 6:30. I climbed into bed, pulled the covers up, and fell asleep in under 5 minutes for the first time since March 6th. Axel Mendler's office was on the third floor of a brick building on Pike Street in downtown Covington. The conference room had beige walls, industrial carpet, and a coffee machine that produced something technically brown and technically warm, but only theoretically coffee. I arrived at 9:15 with Lyra. We took the 2 chairs on the left side of the table and waited. Carla walked in at 9:20 with Spencer and Axel. She was dressed like she was accepting a Lifetime Achievement Award. Full makeup, gold earrings, a cream silk blouse that probably cost more than my first month's rent. Spencer wore a new navy blazer. I noticed the price tag was still tucked inside the collar, hanging against the back of his neck like a tiny white flag. Nobody told him. I certainly was not going to. The documents were straightforward. I, Miriam Fredel, would transfer all claims to the estate assets of Joel Fredel, including but not limited to the law practice known as Fredel and Associates, the residential property, and all associated financial accounts, to Carla Fredel, who accepted those assets along with all associated liabilities. In exchange, Carla relinquished all claims regarding custody of Tessa Fredel, and I received full sole custody with no visitation rights for Carla or Spencer. Before I signed, Lyra made one quiet statement for the record. She said her client was signing voluntarily and wished to confirm that the opposing party had reviewed and accepted the estate inclusive of all disclosed liabilities. Axel confirmed. Carla did not even look up. She was already reaching for her pen. I signed. Carla signed. Spencer sat there grinning like he had just been promoted to CEO of something. The whole thing took 8 minutes, the fastest 8 minutes of my life, and I once ran a half-mile in high school gym class to avoid getting a B in physical education. As I stood to leave, Carla could not resist one final little cut. She looked at me across the table and said she hoped I would finally learn to stand on my own 2 feet without a Fredel to lean on. Spencer nodded along, probably without understanding exactly what she meant, but agreeing on principle because that is what Spencer does. I picked up my bag, walked out, collected Tessa from daycare at 3:15 and drove to our apartment. I made her macaroni and cheese from a box, the dinosaur-shaped kind, because Tessa firmly believed dinosaur pasta tasted better than regular pasta, and honestly, she might have been right. We watched cartoons until 6:30. She fell asleep on the couch with cheese on her chin. I carried her to bed, then I sat on my kitchen floor with my back against the cabinet and just breathed. It was the most peaceful evening I had had since Joel died. 3 weeks later, Carla Fredel walked into Fredel and Associates as its legal owner and began running her new empire. I was not there to see it, but in a town like Covington, you do not have to be there. People talk. Gail still had friends at the office, and some of what happened I later learned from Carla herself during that last phone call. On day 1, Carla opened a stack of mail that had been accumulating on Joel's desk, envelopes she had walked past a dozen times without bothering to open. The third envelope was from the Internal Revenue Service, a notice of unpaid payroll taxes, $47,000 with penalties accruing monthly. On day 3, an attorney in Cincinnati called on behalf of the plaintiff in a malpractice suit against Joel. The settlement had been agreed upon before his death. The $180,000 payment was overdue, and the attorney was very polite and very firm. On day 5, the building landlord called about the office lease. 34 months remained. Carla needed to sign a personal guarantee to assume the lease in her own name or vacate within 60 days. Carla signed the guarantee. She did not hesitate, because in her mind, the firm made $620,000 a year and $4,200 a month in rent was nothing. Just like that, she personally committed herself to $142,800 in future payments. On day 8, Carla finally tried to open Joel's QuickBooks file. Without Gail Horvath, it was chaos. 6 years of categorized entries that made perfect sense to Gail made absolutely no sense to anyone else. Carla hired a temp accountant from a staffing agency. The woman sat down, spent 4 hours clicking through files, and then turned to Carla with the expression of someone who had opened a door expecting a closet and found a staircase going straight down. She said, "Ma'am, are you aware there are over $115,000 in outstanding vendor invoices here? Some of these date back 14 months. On day 10, Gail Horvath filed a formal employment claim for wrongful termination without notice or severance. 6 years of service. Estimated claim, $20,000. Carla called Axel Mendler that night. I do not know exactly what she said, but I can imagine that tea kettle frequency. Axel pulled up his files, read his own advisory letter back to her, reminded her about the waiver she had signed, and said, "I recommended a full audit. You declined. I have documentation." Then Carla called me. I saw her name glowing on my phone screen in the dark of my bedroom. I watched it ring 4 times. Then I turned the phone face down on my nightstand and went back to sleep. Carla hired a new attorney after that. Betsy Polk, from a firm in Cincinnati. Someone with no connection to the case, fresh eyes, and a sharp reputation. Carla told her the whole story. She said she had been deceived, manipulated, tricked into accepting a worthless estate by her scheming daughter-in-law. Betsy reviewed everything: the settlement agreement, the signed waiver, Axel's advisory letter, and the estate filings that Lyra had prepared and disclosed before the signing. Every liability had been listed. Every debt was in the paperwork. Nothing had been hidden. Nothing had been fabricated. Miriam had not lied about a single thing. She simply had not volunteered information about assets that were legally hers and legally outside the estate. From what I heard later, Betsy told Carla the truth in words that left no room for hope. Carla had been represented by competent counsel. She had been advised to wait for a full audit. She refused. She signed a waiver. The settlement was voluntary, mutual, and documented. No fraud, no case. Apparently, the exact words were, "What you have is not a legal claim. What you have is a very expensive lesson." Carla tried to sell the house next. Her realtor ran the numbers and delivered the news at Carla's own kitchen table. After paying off the mortgage, the home equity line of credit, closing costs, and agent commission, Carla would owe approximately $11,000 at closing. The house was not an asset, it was an exit fee. The IRS did not care about Carla's feelings. Payroll tax penalties kept accruing. Carla began dipping into her personal savings, money she had spent 30 years building through those dry cleaning stores. She sold the Burlington location first, then the one in Erlanger. 2 stores gone in 2 months. And she still was not close to covering the firm's total liabilities. Spencer, who had been playing managing partner for exactly 19 days before the walls caved in, suddenly remembered he had somewhere else to be. He tried to remove himself as co-signer on the firm's operating account, but the bank informed him that his signature had created joint liability for certain obligations processed through that account, including a vendor payment plan Carla had set up after the transfer. Spencer hired his own lawyer. A 29-year-old man whose mother had been paying his cell phone bill for 6 years hired an attorney to sue that same mother, claiming she had coerced him into signing bank documents he did not understand. His case went nowhere. He had signed voluntarily as an adult, with no documentation of duress. But the lawsuit itself, Spencer Frettel versus Carla Frettel, was real, filed in Kenton County, case number and everything. Mother and son, the inseparable team who had stood in my kitchen measuring rooms and making plans, were now paying separate attorneys to argue against each other. Honestly, I could not have written a better ending if I had tried. And believe me, during those long nights in my apartment while Tessa slept, I had imagined quite a few. The last time Carla called me, I answered. She was crying, and not the performative grief I had seen at Joel's funeral. These were real tears, messy tears, the kind you can hear through a phone. She said she was losing everything. She said she did not know. She said she needed help. I listened. I did not interrupt. And when she finished, I said, "Carla, you stood in my kitchen and told me you wanted everything except my daughter. Do you remember that? You said you did not sign up for someone else's child. You wanted the house, the firm, and every single dollar. And I gave you exactly what you asked for, every single piece of it." Then I hung up and went back to helping Tessa glue macaroni onto a piece of construction paper because she had decided she was making a portrait of a horse and needed more noodles for the main. That night, after Tessa was in bed, I sat at my little IKEA table, the one I had assembled myself with a YouTube tutorial and a butter knife because I could not find the Allen wrench, and opened my laptop. I filled out an application for a paralegal certification program at Gateway Community College. Tuition was $4,200 a semester. My bank account had $1,085,000 in it. I could afford it. On my nightstand, framed in a simple black frame I bought at a craft store for $6, was Joel's letter. I read the last line every night before turning off the light. "Don't let her take what matters. She can have the rest." Carla took the rest. I kept what mattered.